All right. Hi, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for July 7th, 2025. Brad, go ahead.
And I got to tell you, I'm really excited about today. Today is really some good, somewhat novel or novel twists on what I'd call routine cases. But
Mm.
starting with one novel thing, though not novel for Connecticut, is a case of reverse discrimination. We all know that there was not a exactly similar suit, but a suit that went to the U.S. Supreme Court with Frank Ricci
Yep.
out of New Haven, right?
Mhm.
But here we have a former lieutenant with the Hamden Fire Department. He's filed a discrimination suit because he claims that even though he was first on the list, now he's a white male, even though he's first on the list, he claims that the city articulated a policy for becoming more racially diverse and hired the lesser qualified African American or black male who was second on the list and for the position of fire captain. And this is back in January of 23. So that really sums it up. And you've got this reminds me of LA, right? Remember the LA fire chief was accused of saying no more good old white boys running this.
Mhm.
Um,
Yeah,
although that
there was a chief. I don't think it was L.A. though, but
wasn't LA.
no,
Oh,
I think it was but I know what you're saying. I think it might have been Kansas City, if I'm not
oh, could
mistaken.
have
I
been.
don't know. It was one of the metro cities, but yeah,
Yeah, and so, but here that kind of derogatory comment here,
yeah.
regardless of how anyone feels about DEI and everything, when somebody's saying, listen, we're trying to kind of break the ice and we're trying to get more, minorities into leadership positions who are qualified, and
Hmm.
here right,
Hmm.
the individual was qualified. Now there's no requirement in the law, I presume, in Connecticut that says you have to hire the first on the list, right? But when
Right.
you acknowledge, when the city is saying, listen, we are intentionally going to pass up, if I'm not saying this is what they
Mhm.
said, but if it's
Right.
interpreted that they said we're intentionally going to pass up white or non-minority candidates for a minority, now that would make out a claim for, right, whether it for reverse discrimination.
Yeah, I started law school in 80, started law school in 80, I think it was 81, 82. And we were watching the cases, and I've been kind of following the cases because there's a lot of questions over the years. The Bakke case, I don't know if you remember the Bakke case, but that was the U.S. Supreme, it affected me. It was a medical school case where the U.S. Supreme Court, similar to the Ritchie decision, said that you can't have set quotas. And but they said you can have affirmative action, but you can't have set quotas. And at Bakke, they had a set quota. So that kind of did away with quotas. But
Yeah, but
um,
then we have minimum quotas like Boston, Syracuse City, right? It's got to reflect the minorities in your
no, 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 no,
community.
no, 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 no. You're putting the cart. This is the problem. You put the cart in front of the horse. You have to make a determination. And originally they said that again, this is professors talking to students, trying to explain where the law is going, trying to predict where the Supreme Court is going to go with this.
Right.
But the sense was that you had to have a judicial finding of past race discrimination to justify an affirmative program that was going to be race conscious. Okay. And that was what we were taught in school. And that there was a big debate. The Supreme Court hadn't decided it. Subsequently, the Supreme Court did decide it. And they said, no, but the entity itself needs to make that finding. They have to make a finding basically that there has been past discrimination. And to remediate the past discrimination, you can have some sort of a affirmative action type approach, not affirmative action, but some sort of a program that officially sort of remediates that issue. Okay. Now, in the absence of doing that, this is the open question. Can a fire department, and I'm not sure about Hamden, I don't know about their racial makeup, but can they just turn and goes, you know what, we're gonna start doing this without that sort of look back? Have we been guilty of this? Is it statistically proven? And then are we going to do that? So I think that remains one of the concerns that I had in terms of looking at this, looking at the facts here, this case.
Yeah, and I think that's true. I think here, because when we see the Department of Justice, who probably won't anymore, but right under this
Right,
administration, but when we've seen the
right.
Department of Justice enter into these agreements with municipalities,
Mhm.
it, as you suggested, it always starts with right the rate of minorities in the community or percentage in the community is this, the department's at this, and you need to get to community parity.
Right.
Here, we don't know if that's been done, right? We
But you
don't
don't,
know if
but
the
you don't
department
have
is
to have,
saying.
you don't necessarily have to have parity. And that's the thing, just
Right.
because you're like, because otherwise, let's say you're in a 99% white community.
Right, 1%.
You can't say, "Oh, we can't hire you because you're not white."
Right,
So the whole idea there, but it's premised on a finding or conclusion that there has been discrimination. Doesn't necessarily have to be intentional discrimination. You can show a disparate impact, okay? But as long as there's been some finding that warrants that race conscious decision, then you're
right,
over the hurdle. But if you haven't done that, that's the question. Now, how would a lieutenant know whether or not the department had done that? And that's, not necessarily
right,
everyone in the organization would be aware that that finding had been made.
right.
You know?
Sure.
And, truth be told, sometimes you wonder whether or not the people who are making that decision maybe have a social agenda that it aligns with them. Oh, yeah, of course we have.
Right.
So again, you have a truthfulness part of that as well.
And there's more that goes into it, right? Just okay, well, we haven't had enough apply. Okay, but we've encouraged, minorities to apply. We've encouraged them to get promoted. We've encouraged these things, but they still haven't. That may not be an issue with the department.
Right, but it still shows a disparate impact. And
Right.
that's where the disparate impact is the statistical part of that. And I remember discussing that in law school, and it hadn't been decided at the time, but the question was whether or not disparate impact was indeed going to be enough. And the court has concluded that it is.
Yeah. Yeah.
Yeah.
And so,
So
look, if they're trying to correct that, maybe. If they're
yeah.
not, but that ultimately is probably where they're going to focus, because I don't think you can just announce all of a sudden, right, without the finding. You can't just announce we have a problem or we're going to remedy a problem that doesn't exist.
Right. Exactly. And I think that's where we're at. So we'll see how it
Perfect.
shakes out.
All right,
So
next one I love. Next one is just such a good case because even in must-have policies, one of our first policies we released was talking about essential job performance requirements. And NFPA 1582, which is now NFPA 1580, all combined, has a better list than it did in 1582 of some of the essential job performance requirements. And
mhm,
there are a couple of mental health ones in there, such as
mhm,
being able to work as a team in a team atmosphere and
mhm,
hectic and dark and tough conditions. So
mhm.
here, we talked about that and we addressed that in must-have policies. We talk about it every so often here with ADA, and here it comes into play. This is why I love this case, because it really, you got to have more than a topical understanding of essential job performance requirements, and this case helps this. So here's what we got. We have a court ruling. This is not like the last one, an allegation. This is an actual ruling, and I think I agree. I think the court, I'm confident I agree. The court did the right analysis here, and everybody should understand it because I think people get it wrong. So we have a judge ruled that the city of Chicago violated the Americans with Disabilities Act, as well as the Illinois Human Rights Act. I guess they're similar, when it offered a job to an individual conditional, right, as a firefighter, conditional upon his successful completion of physical examination. We'll get to the mental in a moment. Now, just to point out to everybody, that is the right order. You don't do the test, do a physical exam, and then offer a job or not. That violates federal law, right? You do the reverse. Offer the job, then give the physical. Here, the physical discloses that he had a history of obesity, depression, anxiety, and suicidal ideation. And so the medical director then said, okay, now we want you to undergo a psychological exam. And of important note, not every candidate was required to undergo that psychological exam. Now, that's raised as one of the issues. The court doesn't have an issue with that. The court,
Right.
right, correctly so, says follow-up exams are authorized
Right.
if they're
Well,
needed.
as long as they're reasonable. You know,
Right.
as long as they're reasonable. I think that's one of the subholdings in this that reading it you might miss. And I think many of the headlines that I saw mistook that for the main holding.
Oh, no.
And I know it. I know. Well, that's, folks that just they only read the headlines and
Right.
then they run with whatever they think the headline said. But there was a couple of headlines that I saw that said that in order for you to impose any sort of mental requirement, mental exam, you have to apply it to everyone. And that is not what the court said. That's
No,
absolutely
no.
not what the
Of
court
course,
said.
that follow-up exams, even though they're specific to that individual, are totally legitimate if they're warranted, right?
Right.
So if somebody presented with a heart disease, right, you could, if you wanted, do a follow-up. If somebody had a history of seizures, you could, if you wanted, do a follow-up, right? You're not going to offer the extreme test to everybody when there's no warranting of it.
And that's the point. And that was the point. But again,
Not the main holding
some
here.
of the folks that just stay at the headlines kind of run with this stuff, and then other people see it and they go, "Oh, that's what that case was." No, that's not.
No. So the main holding here, even though that was an important holding about the
Yeah, it
follow-up,
was. Absolutely.
the main holding up here is over, does the disability relate to the essential job performance requirements, which is so easy to say, but here, the reason I love this case is you get to see it in practice. So remember, every employer, and it's not 1 hour ago, I just sent an email out to somebody who said, oh, we've got this issue with this person. We don't think he could do the job. I said, do you have essential job performance requirements? Because if you don't have essential job performance requirements, the question of can somebody do the job is moot. They can because you have no requirements, right? So they did, however, the city does have requirements, but they go through this mental health evaluation, finding issues or whatever, but everybody agreed. And I'm surprised the lawyers kept pushing this once the question was asked, but the doctor, the city, they all agreed that first, the screening really wasn't a fit for duty screening.
Right.
And second, that the results of the screening don't indicate that that the individual could not do the essential job requirements. Well, wait a minute. So then why are we saying you can't be hired? If the screening isn't for the purpose of determining whether you can do the essential job performance requirements, and the screening doesn't show that you cannot do the essential job performance requirements, what are we saying? So that's the holding of this case, that whatever your reason for disqualifying somebody is, it's got to be because you cannot perform the essential job performance requirements for that position. And one step further, that there's no reasonable accommodation that a fire department could make to then allow you to do it.
But that's going to be left on the table. They've got to look at that going further. And we had an interesting discussion with some folks in LinkedIn on this case. And when I first read it, I said, "Oh, the court's got it wrong," because I was skimming it. Basically, am I going to blog about this case or not? Is it interesting enough? And when I read it, I skimmed it. I said, I don't know. It's kind of complicated. I don't know. And then I went back and reread it. And I said, oh, okay, the court got it right.
Yep.
But here's the thing the court didn't say. The court didn't say you have to hire this guy, okay? The court said you need to figure out a test or some other methodology to determine whether or not this person can perform the essential functions. We're not saying you have to hire him. We are saying you violated the ADA. You violated the ADA. That does not equate to you have to hire him. You've got to make sure, if you want to go back now and make sure that he can or can't satisfy the essential functions. And that's an important distinction as well. Okay, now another question becomes, what's his damages? Okay, if his rights were violated, but it turns out he still wasn't, there might be some damages for that interim. Okay, right. But interesting. I think it's a very interesting case. I got an email this morning about it. Okay, someone asking, is this setting a new standard for hiring firefighters? And no, but there's two parts to this. Okay, one is you've got to, you've already said it, you've got to have essential functions. Okay, and there's got to be a psychological component to that. Okay, the fit, the ability to work, the ability to follow orders, and that type of thing. The other side of it is the test that you use, or not you use, your psychologist uses, has got to be geared toward measuring the ability to perform the essential functions. Okay, so you've got to have the essential functions and then develop or utilize a test that measures the ability to meet those essential functions. And the court said in this case they didn't.
Right. And I want to beg people, do not just look from 1582 to 1580, the essential job performance samples got better, but they are in no way complete. I have a very long list we provided to our must-have policy subscribers, but I have a long list, for example, for interiors, but most of the list didn't come from things like 1582 at the time. It came from calls I got from clients saying, we have an applicant who this. And so I'll give you one example, right? I have in ours, for our policy, what we use is you've got to be able to call a mayday clearly during hectic, scary times. So the call I got was, we have somebody who, when he gets excited, nervous, or scared, stutters significantly, can't get words out. So he couldn't call a mayday. And so we added that in to now what we use for ours, because look, if you can't call a mayday, right? But you better have being able to communicate clearly under stressful situations. I mean, look at, the firefighters just killed again. I mean, if you go back and you listen to the West Webster, same event, right? 20 years earlier, you hear the calmest, coolest, collected mayday being called by the captain there who's, saying what's happening. We got a shooter in the brush. I'm under a fire truck, blah, blah, blah. You need to be able to call a mayday. And if that's not an essential skill in your list, right, then you can't dock someone from it.
Yeah, and it's interesting. There's a difference between job description and essential functions. And if you don't have a separate list of essential functions, the courts generally are going to presume your job description lists the essential functions, but you're better off having a job description, but also backed up with the essential functions.
Right. And the essential functions doesn't have to be a physical. Everyone asks me, like, well, is that a physical exam we're giving? No, I said, no, it's an objective standard to allow your physician to say, okay, you have a 15-pound weight restriction. No, you cannot carry a 40-pound ladder. Right? So no, you can't do it. But people, and let me just throw this out to everybody, and this is almost what we said on our Must Have Policies video that we send out with our policies, but you have to think of your department. For example, here's the example I always give, just to harp on this. If your department drafts and your hard suction is above, let's say on the top of the tanker, and to get this 40-pound length of hard suction off the truck, you have to stand on a little beaver tail, 3 feet off the ground, put your arms above your head, pass it over your head, and turn around and hand it to someone. If when people are drafting essential job performance, they will think about every activity, or I have to pick up a vent fan, right, that weighs 50 pounds, or I have to pull hose to the front door, or I have to climb up an aerial to get to the bed of the aerial to operate. All of those are essential skills. Every department needs to think of your essential skills and what you do in your department to do the job. And one size doesn't fit all. You can't copy your neighbors.
Yeah,
right.
That's a great examples. And I think one area where we have not been real strong is the psychological component. And that's really what this case is about. And you got to think about all the different ways that we expect firefighters to behave, to be able to comprehend, to be able to make decisions in a cooperative way. So that's an important part.
Yeah. And the last question I'll pose to you, because it comes to me all the time, this is really throwing you on the spot, but I know people are going to think about it. Okay, we have somebody who applied for, whether it's employment, volunteer, doesn't matter. We have somebody who applied. They have this specific disability, which we've discovered. They can't do something, but it's not in our essential job performance requirements, but it is so obviously should be. Question, can we now amend our requirements, or should we now amend our requirements to suit this one individual who presented with something that wasn't right? We didn't think about it before. I'll give you my answer after, but what do you think? I know, right? Don't you hate that?
Like why fire service think about this before? So, I think I mentioned before, you have your job description and you have your essential functions. If it's arguably fits in the job description and it's not in the essential functions, I think we've got a little bit of latitude. Okay. But if it's not in either, it's got to be something, it has to be something that is going to cause the person to be unable to do the job. And
Right.
you're set up for a problem. We really need to spend the time, invest the time to come up with a good set of essential functions.
Right. And I think, stretching to create one is not the right idea, right? But if you said, listen, every fire department, of course, you have to be able to do this. Well, then yes, add it, right? I mean, our recognition that we're missing something is the time to add it, but you darn well better. My answer is add it, tell them I'm sorry we didn't think of it, but it's still required. And yes, everybody has to be able to do whatever that is you can't do. I would add it, but I think people really have to look at their jobs. Right. And
it's just you probably need legal counsel at that point. You've got to make a strategic decision. If it's something minor, like one of the examples, remember there was a case with a dispatcher, and they didn't hire the person because one of the tasks that the person had to do was go out and raise the flag every day. That was the dispatcher's duty, to go out and raise the flag. And
right. I remember that. It was a couple of years ago.
It was a police case. Yeah, it was a police case. So, but and the court concluded that it was a function, but it was not an essential function.
Right. Somebody else could have done it.
And that, so you got to really spend the time, invest the time to kind of think it through. And there's no shortcuts there.
Right. I agree. Okay. In any event, that was a great case, and people really got to understand you just your requirements have to meet the actual requirements for your department. Yeah. Okay, let's go to Rhode Island. Some of us are already there. I don't know how familiar you are with this. You didn't give me any warning, but I'm going to go through this anyway. This is really, really, really interesting. So we have the airport in Rhode Island. I imagine there's only one. But
there's only one commercial airport. Yeah, like that.
Okay. So they want to stop the reinstatement of a fire officer who was fired. Now, on the one hand, this looks questionable because the individual who was terminated, who they don't want back, was, I think, the union president, his union president. Right? So right off the bat, you start, whenever you see the union president being disciplined for anything, you start wondering, what's going on. But so we have this lieutenant who was terminated for what sounds like legitimate reasons. We don't know. This is just a suit. And allegedly, he was terminated because he knowingly discouraged applicants from joining the department. Now, let's stop there for a second, because I question whether that is a union-protected activity. If you're talking about the terms and conditions of employment and you say they suck, I don't think anyone should apply here until the city fixes it. I wonder whether that's protected activity or not.
I think it very well could be. And again, there's some facts in the weeds here that are going to be important. But
but nonetheless, he was terminated. The problem for him is, regardless of the maybe our questioning of the reason for terminating him, he was then told to stay out of the station, and he shows up and violates that order for what he says, I'm trying to pick up a union contract, whatever. But nonetheless, he was told not to come to the property, and he did gain access to the firehouse using other subordinates. To me, that's the end of him as far as, but this isn't challenging his termination. This is the airport saying we've terminated him and you can't let him back. One, it would violate the TSA rules, et cetera. So that's what this is. They want to, and you've got to fill in one blank for me, but they want to make clear that he can't be reinstated. And they say that if an arbitrator was going to reinstate him, it would violate the law. Now, I suspect there is going to be a defense in this suit which says failure to exhaust administrative remedies, because the arbitrator hasn't yet ruled. Right? So the arbitrator might say, I agree, I can't reinstate him because, And the question is whether the court is going to jump in earlier than the arbitrator ruling and determine whether the arbitrator can or should be able to make that judgment. Courts are hesitant to stop the administrative process, but there is a rule that if the law prevents it, but some of this is fact-based, not just law.
This is a mess. This is a mess. And for those of you who have taken classes in either collective bargaining or public sector collective bargaining, you recognize the term arbitrability. And there's substantive arbitrability and procedural arbitrability, and the arbitrator decides questions of one and the court decides questions of the other. That whole mess here is sort of incorporated into this. But if we can sort of rise above, I think the sequence of events was the union president is terminated. Arguably, and I think rightfully, there are some concerted activities questions. There may also be some First Amendment questions about, is he free as a person to say this place sucks, don't come to work here. I wouldn't recommend this place. Okay. So you've got, I think now, whether or not
First Amendment activity protected.
Well, this is a private, it's a quasi-public corporation, the Rhode Island Airport Corporation. So there's a factual question now about whether First Amendment applies, but certainly it's funny because they go under state law for collective bargaining. They're not under the National Labor Relations Act. So it kind of makes them seem a little bit public. I can guarantee you they're going to argue that we're not public for purposes of the First Amendment. So there's a little bit of different arguments going on here. Okay. But you've got the union, which he's a member of a local that is within this larger AFSCME local Council 94, very, very large, very powerful union. The guy who taught me public sector collective bargaining was the corporate attorney for AFSCME, really, really good labor attorney, Jerry Cobley. And so he's no longer there, but certainly he's kind of a legend when it comes to public sector law in Rhode Island. And so we've got this factual question now about whether or not he was wrongfully terminated in violation of his collective bargaining rights. So again, you got two things. I would envision two things. The article that I saw wasn't really all that helpful, and the lawsuit didn't really clear up. But if I'm the attorney for the union, we're doing two things. We're filing a grievance.
Yeah.
Okay. We're alleging a violation of the collective bargaining agreement. He's terminated for no reason. We're also filing an unfair labor practice with the state labor board, stating that he's a union rep and he's being retaliated against. Okay. And we're going to pursue both of those. The case and the news article that I read about it, neither of them were clear about whether the upcoming arbitration was the grievance or whether or not it was the unfair labor practice. I believe there was also an unfair labor practice, which usually that doesn't go to an arbitrator, that goes to the state labor board, and they meet in bank. So at any rate, it appears that the airport was concerned about him possibly prevailing at the arbitration, and they were looking to short circuit it. So in other words, like you suggested, they're saying that this is honestly, I should know this. I should know it off the top of my head, but I forget if it's substantive arbitrability or procedural arbitrability, but arguing that this is something that the court needs to decide. It's not for the arbitrator. And you raise a good point about whether or not he's exhausted all of the administrative remedies. So that's where this whole mess starts. But I think it's an interesting question. Like, let's say he is indeed found to be entitled to his job back, but because he violated this federal security issue, the airport's saying he is not eligible to ever work for the airport again,
and can't perform the essential job functions, right? Because he can't show up.
And is it really a security problem? Is it a made-up security problem? Is it a made-up security problem that was the result of the airport's own misconduct in disciplining him and punishing him for protected activities?
Yeah, but here's the thing. So I've had a couple of these cases, and the question of, okay, my original punishment to you was unlawful.
Yeah,
but as a result, I told you you're suspended, you can't do certain things, and you violate that order. Mm-hmm. So the question of law is, and I'll give people the answer, at least the answer that I've had in a couple states. The question is, okay, if the order is unlawful and you violated the the conditions that came with that, right? Does the conditions also get thrown out, right? Or does that second violation get thrown out? And the answer is no, it doesn't.
Yeah, it's not unlike what happens when someone is wrongfully arrested. They're wrongfully arrested, they're incarcerated, and then they try to escape or they get in a fight. And the only reason they needed to escape and the only reason they got into a fight in jail is because they were wrongfully incarcerated.
Right.
Yeah.
But it doesn't matter. That doesn't you're not excused from everything else just because the underlying issue is wrong.
Yeah. Now, the firefighter involved parent, he is alleging that not that he had permission, he doesn't say he had permission, but that he notified them in advance that he was coming.
Right, which is a factual issue for the arbitrator, in my impression, right? And so that's why I think the court, I'm guessing the court's going to say, this has got to go to the arbitrator. These are factual determinations, which are all properly before the arbitrator. The court should not be supplementing its decision for the arbitrator, and normally doesn't anyway, but they're not going to cut off the arbitrator at this point. So my thought is this is going to get thrown out as premature, not ripe, as we say, and you got to wait for the arbitrator's decision. But what do I know?
Yeah, well, it could very well be. We'll see. It's an unfortunate situation, though, and I know everybody's struggling to hire people, and here we are, letting people go. And there was a kind of a nasty comment that he was telling people not to come to work because he was trying to increase his overtime. Which,
that's
that's
tough to believe because there's probably enough overtime.
Yeah, muddying the waters there. So.
Right. All right. Let's go on another. You can't make this stuff up. We've got one municipality in South Carolina alleging that.
We talked about this case, and I told you, I said, I know chiefs in Columbia. These guys are squared away. They wouldn't do what they were accused of, right? And here we have Columbia's response. Yeah. Right.
So we've got the city of Columbia accusing, is it a fire district or another fire department? The Irmo fire department, fire district. Yep. So, okay, it's a defamation case. So here's what's happened. We have an Irmo fire department gets dispatched to a mutual aid fire. Tell me if I'm getting this wrong. Mutual aid fire with the county. They're searching
with the city. It's the city of Columbia. City of Columbia, and then they've merged sort of with the county fire department. So
okay, that's where the county
Columbia, Richland.
Yeah. So Irma goes to a mutual aid fire. They're searching. They're obviously below or above the fire. I think in this case, no, they're below the fire. So or at the fire floor, the floor above them collapses, trapping 4 firefighters. One ultimately succumbs to his injuries. And the allegation is that comments were made saying that the city, killed or injured and was culpable for the death of the firefighters and the injury of the others. And the city in turn says, wait a minute, that's defamatory. You accusing us of the death. I have never seen a case like this before. We always see the first where, you killed somebody, usually brought by a family member.
Do you remember going through this case? There was maybe 2 or 3 weeks ago, 2 or 3 months ago, I guess. You and I spoke about it. And
vaguely.
And you were saying these allegations are outrageous. And I said, I know guys in that department. I know chiefs in that department. These guys are squared away. They would not have screwed this up like this. There's some departments out there that might have, but it just doesn't sound like them. And apparently they were upset about the allegations that were made as well. And again, I have never seen one fire department or one municipality sue another
for defamation.
And
look, it's an intentional act, right? No, it's not. It's an intentional act. So there's no immunity, right? Depending on how, but here's the thing. As part of their job, they need to come up with a reason, right? Irmo Fire Department needs to come up with a reason why things happened. If their results of their investigation were that, okay, the city screwed up, that's not defamatory. That's an opinion, that's why I think this is more opinion based, even though the comments are a little harsh.
Yeah,
I think this gets dismissed.
It's a mess, and they apparently were cited. The city of Columbia were cited by their state OSHA, and NIOSH. I don't know if the reports come out yet, but NIOSH apparently was not leaning toward them either. And the city of Columbia felt like the reason why the state came down and cited them and NIOSH took a dim view of what happened was because of what members of the Irmo Fire Department said. At least that's what it appears. And so, again, going to your point, is it opinion when you're being interviewed about something that happened and you say something happened? Is that an opinion? Is it your recollection or your understanding of the facts? Or, it's
Or is it the truth? If it's the truth, there's the ultimate defense.
The truth is right, the ultimate defense. But again, my knowledge, and I don't know, I don't believe I know anyone from Irmo, but I do know folks from Columbia, and they're as squared away as any other metro department that I'm aware of. So there's no glaring problems there, and the allegations are not complimentary of Columbia pretty clearly.
Right. But I still think it's opinion based. It's not like accusing somebody of a crime, right? It's saying your actions led to his death. That's my opinion because I would have done something differently.
Well, I think they got more specific, and they're talking about failures of communication, failures of command, lack of command and control, and those types of things. So again, is it factual or is it opinion? And
I think it's expert opinion, right? Our opinion is that the fire department didn't do something right or could have done better. That's, I think as far as defamation goes, because I have lost 3 defamation suits. I have sued for defamation 3 times and never again. It is impossible to win. Virtually impossible to win.
Speak from experience.
I speak from the losing experience, right? It is very difficult to win a defamation case. Why? Because the courts always come back and say, it's an opinion. Yes, it sounds factual, but it's just your opinion.
Of what the facts are.
Of what the facts are. And you lose. I mean, that's it. You're not making a factual statement like, this is white, this is black. No, it's like... the fact is you should use a smoothbore nozzle. No, that's not a fact. That's your opinion, right? Or what your opinion is, I would have searched from the floor above or floor below, or right? I mean, that's still an opinion about the best way to do something. So there's no facts on how you fight a fire as far as I'm concerned.
Well, let's put that on the shelf for a minute. But there's another really interesting aspect of this case, which has to do with the mutual aid agreement and the indemnification provision in the mutual aid agreement.
It wasn't meant to include indemnification for intentional acts, I think, such as defamation, I would think.
I'm not talking about, no. Columbia is alleging, in addition to their third-party complaint against the Irmo Fire Department, they brought Irmo in to say that pursuant to our mutual aid agreement, that if we are sued, then you agree to indemnify us for it. So we're being sued because of the death of one of your firefighters, therefore you owe us. Well, that's part of their argument.
And I haven't read the specific indemnification.
Normally
it's not okay. Yeah. Because normally indemnification agreements say we indemnify you for the acts of your people. Right? You're not going to indemnify us for our own negligence. You only indemnify us if we're sued for your negligence.
Well, and I think that's what they're saying. They're saying that your firefighter who got killed was negligent. Your team of people that you sent here was negligent. But here's the thing. I would imagine, like, without seeing the indemnification provision, if Fire Department A responds into Fire Department B's area, and Fire Department A is sued, it's right that B would indemnify. Okay. That's not what we've got here. We've got A going into B being sued and saying, you came into our community and we're now going to ask you for indemnification for what happened in our community.
Very rare.
You see, it's a little bit of, but it depends on the language of that indemnification agreement. So,
which we don't have. Okay. In any event, very interesting. But I personally would be making a motion for summary judgment.
If you're a fire law geek, it's very interesting.
It is. Well, I think all of them. And so the next one is a great point. I almost made the mistake once of doing the same thing, caught it quickly but most people fire departments are so attuned to saying, listen, you're a fire department, so you get the benefit of the 7K exemption. You can do extended hours beyond 40 hours. You can have, right, and not pay overtime with the 207K exemption. Here's the thing, people. 207K and the FLSA generally applies to municipalities. Not all the FLSA, but the 207K applies to public fire departments, municipal fire departments. If you are a private, not-for-profit entity, I don't want to say definitely, probably.
Definitely.
There's no relationship whatsoever.
You can't use 207K. And you can't use the small fire department exemption. Those are both reserved for public agencies.
Yeah, so, right. And so here we have a not-for-profit fire department who's not a public entity, not a municipal. They may be a public entity for some purposes, like freedom of information or open meetings or sexual harassment.
Maybe, but not for
FLSA.
It could not be clearer. It could not be clearer. If you are a 501c3 or 501c4, or even a for-profit company like Rural Metro or some of the other privately owned for-profit fire departments, you cannot take advantage of the 7K. You have to pay, and there is no way around it. You have to pay overtime after 40 hours, assuming that you're otherwise not exempt. But you're not like a manager, an executive, or so on.
Highly compensated, yeah. But no, so this is not uncommon because, again, everybody says, oh, we're a fire department. That's not the test, right? The test is whether you're a public department, public entity. Now, that's not true with all of the FLSA, right? A lot of the FLSA applies to not-for-profits.
This is going to hit them big, okay? Because they, I believe they were working a 4896, okay? 4896 schedule. Now, the 4896, there's two ways that you can sort of level out a 4896 so you end up with the same number of hours each work period. You've got to be either on a 12-day work period or 24-day work period, okay? And then you even things out. The problem is when you put people on a 7-day work week, and you do that, and I usually use like an Excel spreadsheet to create a calendar to look at it all, okay? But you're going to have weeks where these guys were working 98 hours a week.
Right.
It's going to be a nightmare for them.
Time and a half of that base rate is insane.
Yeah, this is going to be very costly. Now, if there's only 1 or 2 employees, maybe you're talking a couple $100,000. If you're talking a lot of employees, this is going to be one. It could bankrupt the small fire department. So. Yeah.
No, I agree, and I have a similar suit I'm pursuing, but not against the fire department. Anyway, I think that is all of them for today. Great cases. I hope the geeky people who are watching us are on our level of geekdom, because these are great things. But look, these are things that cost fire departments big money. And whether it's the FLSA, don't mess that up, or essential job performance requirements, or, these are big deals. Mutual aid. Look, so many people are like, can you review this mutual aid? I know it's standard, the mutual aid agreement. They're not standard if they're not written by you, right? Now, let me just say this one last thing. It has nothing to do with anything other than our mutual aid contract. Nobody has ever written a contract for your benefit. Right? Nobody writes a contract for your benefit other than your lawyer, right? If you're handed a contract to review like the mutual aid contract, it is not for your benefit. You should have a lawyer review it. Anyway, did great week, Curt.
All right, Brad. Well, thank you. And if you haven't already, click subscribe or at least like. We'd really appreciate it. That helps our algorithm, helps people find out about us, discover us, and helps us keep growing. So please click like, please click share, please share the information, and certainly join us in social media with questions and discussions on these cases. Really appreciate it. And that's going to do it again for another edition of Fire Law Roundup. Brad, we'll see you next week.